Hello and welcome to Research channel. What is Bare Act? A Bare Act is a copy of the original law that is open to the general public. This is what do we understand by the Bare Act. And we are also aware that due to usage of legal jargon and language under the Bare Act, it makes it more difficult to understand it. So reading the Bare Act demands extensive interpretational and analytical skills. But despite of its complications, you cannot ignore the Bare Act because it plays an important role for every competitive exams under the law domain, right? Hence, through this video, let's just understand the basics to Bare Act reading. So before talking about the internal construction of the Bare Act, let's just have one point clear. You must have observed that some statutes end with the term Act, whereas some of them ends with the term Code. So is there any difference between them? See, we have examples of different acts like Indian Contract Act is there, Indian Evidence Act is there, Hindu Marriage Act, and there are plethora of examples. So what is Act? What are those statutes which has been ending with the term Act? So these are actually enacted by the legislature after passing the bill in parliament. So in short, whenever there is a need arises to bring a new law, an act comes into existence, right? Now, on the other hand, let's just switch to the code. We have examples related to the code, like Code of Civil Procedure is there, Code of Criminal Procedure, Indian Penal Code is there. So what does that mean? Why not Act is being used? So whenever the code is being used, after the name of the statute, it implies that it is a compilation of laws, rules and regulations that are systematically arranged. Now, if I take the example of Code of Civil Procedure, right, it was enacted in year 1908. So it doesn't mean that before 1908 there wasn't the existence of civil judicature or civil suit. It was there, but yes, it was in the form of the loose compilation, right? So this is what the difference between Act and Code. Now the preamble. So, under the Bare Act, after the index, after the short title, long title, you witness preamble. Now what is preamble? It's a part of statute, but it is not an enacting part, right? The preamble is expected to express the scope, object and purpose of the act more comprehensively than the long title. It may recite the ground and cause of making the statute. So in short, preamble does tell you that what is the main object of making that particular statute. You are well aware about the preamble to Constitution, right? It's very important, right? Before going through the Bare Act, at least for once you must go through the preamble, right? Just to understand that why you are actually reading that law. For your reference, I have mentioned the preamble to the Competition Act 2002. You can just go through and understand that why the Competition Act was enacted, right? Why it was made. So preamble is very much crucial to start off your Bare Act. The other basic thing which comes under the Bare Act reading is proviso. Now what is proviso? A proviso is subordinate to the main section, right? The function of a proviso is to qualify something or to exclude something from what it is being given under the main provision. And it falls within the scope of that main provision. It doesn't go beyond the main provision. In short, it just places a condition to the main provision to which it is being annexed to, right? And it often starts with the term provided. You can see the example which I have mentioned over here, right? I have mentioned the Article 3 to which a proviso is being annexed, right? So you can refer it. Next crucial thing that comes under the Bare Act is non-obstinate clause. Right? So these kind of clauses often starts with the term notwithstanding. Hence, non-obstinate clause empowers a legislation or a provision in which it contains to override the effects of any other legal provisions which is contrary to under the same law or any other laws. Hence, this clause basically removes all barriers which might arise out of any other law in the way of operating the principal provision, right? So wherever, right, under the section, if you are seeing the term notwithstanding, then that very provision will have the prevailing effect to their contrary sections or to their contrary provisions. Next important thing is saving clause, right? So these kind of clauses often starts with the term nothing. So a saving clause is designed to preserve certain rights, duties or privileges that might otherwise be destroyed by general enactment containing an amendment to or repeal of existing provisions of law. Like if I take the example of section 482 of CRPC, right, this is a saving clause and it talks about the inherent power of the High Court which is available per se, right? So in simple terms, it means, according to section 482, that High Court should first examine whether the prevailing situation is covered by any other provision which is given under the CRPC, and if not, then inherent powers of High Court will apply. Now there is this one announcement that Jurisearch Academy had started the enrollment of new UGC NET batch. So to know more about the course, please visit the link given under the description box. Thank you for watching this video. If you want next series to the basics of Bare Act reading, then please tell us your view in the comment section box. Don't forget to like, share and subscribe Jurisearch channel to get the further updates.